Interpreter with us, if you can raise your right hand for me, please. Do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, guys, this one kicks off in a unique way. A translator is sworn in, signaling that language won't be a barrier in this intense courtroom showdown. From the jump, you can feel something big is brewing. When a translator's involved, it means every word matters. And trust me, this case has layers. The judge is all business, and we're about to see legal gears turn fast. Buckle in, because what follows isn't just procedure. It's the kind of real-life courtroom drama that pulls no punches and leaves no doubt about the stakes.
All right, so the first thing, my understanding is that he is requesting a jury trial. Is that correct?
Judge, before we reach that matter, I would like to ask the court to ensure that Mr. Salinas is desiring us to represent him. I know this was a question before, but before we proceed to jury trial, I think I need to put it on the record again if he wants us to represent him or not.
Oh, well, what I can tell everyone, this is an old case. I know that your firm was wanting to withdraw, and that motion was filed and the court denied it. And if he wants another attorney and does not want you to represent him.
Now we dive right into the fire. The defense raises a bold issue. Does the defendant even want them to represent him? That's a red flag before trial even begins. The judge isn't playing games. Either the attorney is ready or the defendant better find someone who is. Trial set for tomorrow. No delays. Tensions between client and lawyer are boiling. And when legal representation is in question this close to trial, you know chaos is lurking. This isn't just about rights. It's about readiness under pressure. One move here could shift the entire course of this case.
Then he needs to have an attorney who's prepared for trial tomorrow, because this specific case will be going to trial tomorrow.
Judge, he has been trying to fire us for 2 months. And we did not attempt to withdraw on our own request. We attempted to withdraw because he asked us to, and he's been asking the court to appoint him an attorney since July 20.
No, he has not.
Those motions are in the file.
No, he has not been asking for this court to appoint him an attorney. And if my understanding is, one, you have not been the attorney who's been on this case. There's been another attorney from your firm. And where is that attorney? Because
Judge,
that's the
he's
attorney.
resigned.
No, that attorney needs to be here because he's listed as his attorney.
Anthony Wilson, or is that who you're speaking of?
No, I'm speaking
Carlos
of,
Ramirez?
yes, where is he?
I'm not sure. I think he is down taking care of other business.
He needs to come up here and take care of this business.
Okay.
Things hit a new level here. The defense insists the defendant's been trying to fire them for months, claiming he's asked the court for a new lawyer since July. But the judge hits back. Those requests weren't made properly. Then comes the twist. The attorney listed on the case isn't even in court today. The judge demands answers and wants that specific lawyer present. No excuses. The courtroom energy shifts from tension to urgency. Deadlines loom, trial is on the doorstep, and the defense team is scattered. It's not just about representation now. It's about accountability right here, right now.
But Judge, I did see in Odyssey that there's been some pro se motions filed requesting an appointed attorney.
Let me just explain to everybody how pro se motions work. When somebody has retained counsel, their pretrial motions are not heard by the court.
Of course.
Their pretrial motions are only heard if they are pro se. He is not pro se. And Carlos Ramirez, who has been here, needs to be here. He knew that this was here.
Sure.
So I do not understand why he's not present.
Okay. But the issue that we need to determine is if he, just for the sake of trial, and I understand, Judge, that you're going to call this case tomorrow regardless, but for his sake and ours, I need to put on the record if he is wanting us to represent him at trial.
All right. So what I'm telling you is the person.
This moment is pure tension. The judge lays it down. If the defendant has a retained attorney, certain motions won't even be heard. Meanwhile, the expected attorney is missing, and the judge is not having it. Then comes the real clash. The defense objects to the case being live-streamed, fearing prejudice for tomorrow's jury. The judge? Not fazed. Objection overruled, and the courtroom gets a lesson in legal process. Rulings stand, no debate. It's a power move, and the judge's authority is clear. No delays, no distractions, the system rolls forward, and you better be ready.
To be asked those questions and to put it on the record is Carlos Ramirez, not you.
Well, I am also listed as attorney of record, Judge.
Well, I'll have them check to see if that's the case. Ms. Ferguson, can you look and see if she's listed as an attorney of record? Or is it just their firm?
Judge, I see Carlos Ramirez, Stephanie Collins, Anthony Wills, that all listed as his, attorney.
And are you Stephanie?
Yes.
All right, ask your questions.
Mr. Salinas Salgado, before this goes on, Judge, I would also object to this being broadcast on YouTube in the event that potential jurors are watching this right now, knowing that they're going to be called to this court tomorrow. I think that would be prejudicial, Judge.
All right, your objection is overruled. Do you have questions for him?
And I would object to the overrulement for the record. Mr. Salinas?
Just a moment. So this is how things work.
Here, courtroom control takes center stage. The defense tries to argue further, objecting to the judge's rulings themselves, and gets shut down hard. The judge schools the room on how objections work, making it crystal clear. Rulings are final, and there's a process to preserve error. This isn't just legal theory, it's a real-time masterclass in authority. Then the key issue lands. If found guilty, will punishment come from judge or jury? The defense aims for jury punishment but still needs clarity on representation. The judge demands order, questions first, answers second, and she's not backing off.
You make your objections, I make a ruling. There is no, I object to the court's ruling. The court's ruling is the court's ruling. And if you're intending to preserve error, how you preserve error is you make a request, I make a ruling. That's your error. It's preserved. Preserving your error is not if I overrule an objection or I sustain an objection and you say, well, I'm objecting to your overruling or sustaining an objection. Legally, that's not how things work. So your objection to the broadcast is overruled. Now, here's my question. Is he going, if he were to be found guilty, is he going to the court for punishment? Or is he going to the jury for punishment?
We have filed a motion for jury, but I still need to determine if he wants us to represent him or not.
All right, so this is what I need you to do. I need you to listen to my questions, answer my questions.
Now it's the judge's turn to take control fully. She starts explaining the entire trial process, discovery, offers, and defense rights, directly to the defendant. Every step is spelled out with precision. She's laying the legal groundwork, making sure there's no confusion when trial hits. The defense hasn't received the plea offer yet, so the judge pauses the action and orders the offer to be delivered immediately. This is more than procedure. It's about ensuring fairness before battle begins. Everyone's on edge. One misstep could trigger chaos, and the clock is ticking towards trial.
And we will go in the order that I'm giving you. So, Mr. Salinas, do you understand this process? Have they explained to you about jury trial? Well, let me strike that question. Don't answer that question. Let me explain to you. In this court, since you've been here, this is the process for this court. First thing that happens is I make sure that defense attorneys have all of the discovery. What is discovery? Discovery is items or evidence or proposed evidence about your case. So if there's a video that's about your case, the defense is entitled to have that. And I make sure that they have that. And if it's something that they say they don't have or something that they think they should have and maybe the state has and hasn't turned it over to them, I'll make sure that they have that.
This part is the calm before the storm. The defendant finally receives the offer from the state. One question remains. Would he take the deal or face a jury? His answer? No deal. The judge doesn't flinch and confirms the final move. Trial by jury is on. This is the moment decisions solidify, the legal foundation is locked in, and now there's no turning back. Stakes are real, tension is sharp, and all eyes are on the outcome. What began with confusion is now focused. A showdown is coming, and it's going to unfold in front of a jury with everything on the line.
So in your case, your attorney has said they have all of the discovery. So that means that all of the evidence that you're entitled to, they have that. Your attorney, Mr. Ramirez, has said that's the case. Then the next thing I do is I tell the state in this court that you have to tender an offer. That offer will be given to your attorney. That attorney will go over that offer with you. And then if there's something you don't understand about the offer, then you're to ask your counsel. Do you understand?
See.
Okay.
Yes.
So yes or no, has an offer been tendered to you in this case?
No.
No.
All right. So this is what we're going to do. I'm going to have you sit down. The state will let this defense attorney know, because I know this defense attorney hasn't been here. It's been Carlos Ramirez. The state will let them know what the offer is. And then your attorney, who's here today, will let you know what the state's offer is. Then you will let me know whether or not you're accepting the state's offer or whether or not you wish to go to jury trial. Do you understand?
See.
Yes.
All right. All right. So first things first, Mr. Salinas, did you receive the offer from the state?
See.
Yes.
All right. Did you understand the offer?
See.
Yes.
All right. So knowing what the state's offer is, were you able to reach an agreement with them or no?
No.
No.
All right. Are you asking for a jury trial?
See.
Yes.
All right.
As the scene closes, the courtroom is locked in. No more questions, no more motions, just clarity. The defendant has chosen his path. He's going to trial, and the jury will decide his fate. The legal system, in all its complexity, has funneled down to this moment of simplicity. Defendant, prosecution, jury, verdict. The judge has steered the chaos into control. The defense has their marching orders, and the process will unfold by the book. No drama left. Just justice, ready to be served. Next stop, the courtroom floor, and everything is on the line.